Доброго дня, шановні учасники
Good day,
конференції.
dear participants of the conference. It's a welcome to have you here with us. It's our second session. It's my honor to moderate this second session of the fifth scientific and practical conference dedicated to the issues of considering tax cases. First thing to be mentioned is that the challenge we covered with by such wonderful professionals in this field, and it's also a pleasure that we can hear about these ideas not only from the representative of the judiciary, not only by the members, but also we will be able to hear from our European colleagues. Please be reminded, especially speakers, that there is up to 15 minutes for each intervention. And if necessary, I will remind to you that you need to speed up in case necessary. So now I give the floor to Mr. Heinrich Stutzmann, who will cover the challenges of law enforcement and possible ways to overcome them. Dear Mr. Heinrich Stutzmann, the floor is yours.
Thank you very much, Mr. Olenda. I hope everybody can hear me and see me, which is not so necessary. Dear President of the Supreme Court and Administrative Cassation Court, dear colleagues and dear participants, it is a great honor for me to take part as a guest of your conference. I'm impressed by the great variety of the topics that form part of this conference. And thank you also for the good organization that I've seen so far, despite the difficult circumstances you have in the Ukraine at the moment. And please let me express my very deep compassion for the pain and damage for the Ukrainian people and suffer from the unjustified and brutal Russian aggression. But to start with my topic are the problems of law enforcement. I would like to ask or to start with a provocative question. Can the taxpayer object to his lawful tax assessment by arguing the state doesn't tax the others efficiently, especially my competitors? Or to put it very simple, can one taxpayer say, I don't want to pay any taxes because my neighbor is cheating? My contribution today is focusing a bit on the fundamental principles that have to do with this topic, and to give you a short overview over the German case law concerning this, and I will finish with short conclusions. I hope I will make it within the 13 minutes left, and I hope I won't see a red card. So it's time to start. Yes, the fundamental principles for claiming an effective law enforcement are as follows. There's, first of all, a procedural law impact that is the protection only of individual rights. A popular lawsuit is not admissible. So the taxpayer can claim only to save his own rights and argue that his own rights have been violated by a tax assessment. A class action is not admissible in German court. You cannot say my neighbor is taxed not hard enough, so I won't pay taxes. That's generally is not admissible, and you can only bring your own tax case to the court. That's the procedural, one of the procedural aspects. The substantive law, of course, gives a lot of others fundamental principles. The first of all is the principle of equal treatment of the law. That is part of the basic law in Germany, as in other parties in other countries as well, of course. Yes, And this substantive law follows the equal treatment, and the main aspect is that the state, and the tax state as well, is not allowed to treat persons different or unequally that find themselves in comparable situations without being reasonably justified. So the taxpayer can say, I have to pay as much tax as another one has to pay who is in a comparable situation, who earns the same amount of money, for example. But it does not give him the right to say, I know from wherever that another person, especially a competitor of mine, has to pay less taxes, and I want to have that as well. So the reason for that is that you don't have a right for the repetition of errors. And the tax authority that administers the tax is bound to tax law. And if they have made a mistake once, you don't have the right to repeat this error over and over again. Another aspect of the principle of equal treatment of law is that the tax authority has to ensure that enforcement of tax law is administered in an effective way. So there were, in the last decades in Germany, there were two, I would say, famous decisions of the Constitutional German Court. And they said in two cases, we had such big problems with the equality, the equal treatment, that there was, which is the key word for all of this problem I'm presenting you today, they had a structural deficit of enforcement. That is the keynote for this very special problem. Another procedural aspect is if a financial court or the federal financial court is the opinion that a tax law is violating the equal treatment rule of the Constitution, it cannot do so by itself. It cannot say, I don't allow you to tax someone. It is the exclusive jurisdiction of the Federal Constitutional Court to set aside tax law, a statute, if it is the opinion that it violates equal treatment. So the second part of my contribution has to do or wants to give you a short insight into 2 or 3 important cases where this structural deficit of enforcement of tax law has to be the main topic. The first case is quite some years ago. It's from 1991, and it was on the question of taxation of interest. At that time, it still is, interest on saving accounts is taxable in Germany, but there was a so-called bank decree for the banks that paid a lot of, was very generous as to the relationship of trust between banks and their customers. And I don't want to go into details, but the Federal Court of Auditors objected to that practice and said that around only 25% of all the people who gained interest in Germany were proper taxed, so 75% were not. And one tax official filed a claim against his own tax against his own taxation, and this case was brought finally to the Federal Constitutional Court. And this Federal Constitutional Court said this practice of taxation violates the Constitution, it's unconstitutional, and it's only allowed for 1.5 years to continue that, and after that it would be void. The reason was there was a structural deficit in enforcement. That is when this keynote this keyword was more or less invented. And they gave a good reasoning, which is still state of the art for this problem in German tax law. The main reasoning was that the legislature, the tax legislature, has to support tax honesty with some sufficient control options. So on the one hand, there's the declaration principle. The taxpayer has to declare what his earnings, etc., and interest in this case were. But on the other hand, you have a verification principle as well. So
з іншого боку застосовується принцип.
Was it too fast?
Sorry, please continue.
Yes. Проблеми з перекладом. We have a little bit problem with translate. Wait 30 seconds, please. Okay?
Yes, I wait.
Please continue.
Yes, thank you. So you have these two sides, and that goes back to what Professor Kucharienko said this morning, that you have two sides of obligations, and you have to focus on them. These deficiencies in enforcement of tax occur every day, of course. We know that in practice, it's not possible to have a perfect taxation, and the Constitutional Court says that this, of course, is not at all a justification for not paying your tax if you say the tax enforcement is not perfect. But if it goes as far that you have, on the one hand, a collection rule that says you have to pay that and that taxes, and on the other hand, you have a rule to collect the taxes that is structurally of an oppositive of an effect that are colliding. So if this is the case, and the effect is that largely taxes cannot be enforced and not collected, this failure is attributable to the legislature, then it comes to the effect that there is prohibition, a violation of the basic law. And in this very special cases, it can come as far that tax can be void. To the last point, maybe a bit more, the attribution to legislators is only possible if you have can say that the parliament, the one who makes the law, has regulated himself a rule that is contrary to another rule, or he has accepted a practice that the administration is so bad that it is completely opponent to the substantive law. It is the last rule to make these contradictions between these two rules have to be obvious to the parliament, to the legislature, and only in these cases you can say that there are problems, there are hard problems, and the legislator has to see them, and if he don't react, it can lead to an avoidance, to the voidness of the taxation. This ruling was more or less repeated in a comparable situation in the year 2004. It was about speculation tax, and this time the Constitutional Court said that the legislature does not have 1.5 years to change the problematic situation, but it said it has to stop now, and it's already void. So in this special case, there was a tax professor who brought this case by himself, his own case, and he didn't have to pay the taxes for a very special deal he has made for selling privately held securities. The most recent case was as of last year with the Federal Fiscal Court in Germany. And in this case, there were a catering business. And in Germany, you have two possibilities as a catering business to run your shop, or to do it and to record it. Either you do it with an electronic cash register system or with an open cash register. Both of them are possible within the law, but as you might imagine, with an open cash register, you have much more possibility to tampering and not declaring as you should what you have earned, and so avoid taxes. So in this case, we had a rather big gastronomy who had this specific electronic cash register. So they didn't really have a chance to cheat, I would say, in a short, but they knew that some other gastronomy close to them that, excuse me, 15 minutes passed, but I had an interruption. They didn't have the chance, and they said they want to be treated equally. We also want to have 15% off because we didn't have the chance to cheat as the others have. And in this case, the court, my court, didn't argue and didn't agree on this structural deficit of enforcement. They held that there were sufficient possibilities for the state, for the tax administration to control it. And it was not only up to the decision of the taxpayer to declare his true income, but only the authority had sufficient possibilities also with the open cash register to set to be sure what the right tax is, and there was sufficient risk. There has to be sufficient risk that there is an audit and that he is gotten, and cheating does not lead to a success, and the risk of detection is high enough. So in this case, even if there was a structural implementation deficit, the legislator had done maybe not too much, but in this case sufficient to avoid tax evasion. But one thing had to be said, that the legislator must observe the actual implementation and to check on a regular basis whether or not there is a sufficient risk to be detected if you decide to cheat with your taxes. And this has not to be forgotten. I come to the conclusions, if you allow me. Yes, a structural enforcement deficit is only an extraordinary legal consequence of the lack of effectiveness of the law. It's not enough to say, I know someone who has cheated, so I don't have to pay my taxes, of course. This is also respect to the separation of powers between the legislative, who makes the tax law, the executive, the authorities who make the decisions, and the judicial the one that control the tax assessments. And this separation of powers requires that we have to respect what decisions have to be made, and the financial management of the tax authority can generally decide where they put their focus on where they put their manpower to observe the market and the tax, whether or not the people are following the tax rules. But there is one point where the taxpayers really can exempt from their obligation, but is on a rather high level. That is if the legislator completely fails to establish the equality. But this very high level must be obvious. It must be an obvious violation of equality, and it must be more or less easy for the legislator to avoid it. They must have the chance to avoid it, and if they don't, and it's an obvious problem, then it can come to the case that the jurisdictionary has to say, this is void, this is contrary to the constitution, but it's the absolute exemption and not the rule. Well, thank you for your attention, and thank you for the translation. Maybe I was a bit too fast speaking. Thank you.
Дякую, пане Генріху. Дійсно, доповідь була ґрунтовна.
Thank you very much, Mr. Stutzman. Indeed, your report was very detailed and very topical for Ukraine. It was indeed very interesting to find out how taxes are enforced in Germany, because we have many features in common between our two countries. I fully agree with you when you say that the authorities should ensure proper equality in tax enforcement for all taxpayers. Speaking of the technical problems with interpretations, my sincerest apologies to all the participants. Should there be any problems with understanding the speakers, please know that you will have access to printed materials, to electronic materials on our conference. Now I'm very pleased to give floor to our next speaker, Judge Felipe Eduardo Neves. Judge Felipe, we invite you to take floor, please.
Hello, I am Felipe Eduardo Neves, so that's me. Your Portuguese is very good. So I will try to speak slowly to make translation easier. I would like to start by thanking to the President of the Supreme Court of Ukraine the invitation made to participate in this wonderful conference. It's a great honor to be here today and participating in such a fantastic event with such distinguished participants. I would also like to express my congratulations for the organization of this event under these terrible circumstances. My prayers, the prayers of the Portuguese people, are with you and all of the Ukrainian people. So my presentation today is about the reform that was implemented by the Portuguese government to address administrative and tax courts caseload and performance, because in Portugal we had a huge problem in administrative and tax justice because there were cases that were waiting for decision for 5, 10, 15, and even 20 years. So that was a huge problem for administrative and tax justice. Next slide, please. Just to give you some context about the Portuguese and administrative and tax jurisdiction, we have in Portugal 16 first instance courts that are spread by the main districts of Portugal. We have 2 second instance courts that are pointed out in green in the board, in the presentation slide. One located in Lisbon, that's the Portuguese capital, and another one located in Oporto, that is the second biggest city in Portugal. We have also an administrative and tax Supreme Court located also in Lisbon. And this is the configuration of the administrative and tax jurisdiction since its first beginning, since 1989, that the jurisdiction is designed like that. So in Portugal, I believe that is the same in Ukraine. Administrative and tax courts are separated of the so-called common jurisdiction. The common jurisdiction as criminal courts, civil courts, labor courts, commerce courts, and administrative and tax jurisdiction is a separate area from public justice. Next slide, please. So these administrative and tax courts, since its very first beginning, were struggling to deal with the caseload. Just to give you an idea, at the end of 2018, more than 15,000 cases were awaiting for decision at first instance courts for more than 6 years. In Portugal, for many years, we were discussing the reasons for this situation, and we may say that the reduced number of judges, the increase in litigation, and several legal reforms, because in Portugal, each year with the state budget, lots of changes are introduced in the administrative and tax regulation, and that changes typically triggers interpretive challenges, and later on more disputes in courts to solve that issues. So this situation had a terrible effect in the trust in the administrative and tax justice system, as well as in the economy, because we need to have courts working properly in order to address the disputes that they need to solve. Next slide, please. So in order to address this huge problem, the Portuguese government and in 2018 implemented a reform, and this reform, I would say that brought 4 main measures to tackle this problem with administrative and tax courts. The first one was the setting up of teams with the only mission to resolve cases that have been filed up to the end of 2012 and that were pending for decision. Roughly, this number was around 12,000 cases. Another key measure was to implement specialization in tax and administrative courts where the caseload was higher. Another measure was to increase the number of judges in administrative and tax courts, differently of what happens in the so-called common jurisdiction, where they have an annual recruitment of judges for that courts. Administrative and tax courts do not have an equal policy of recruitment. Just to give you an example, between 2010 in 2014, 0 judges were recruited for administrative and tax courts. And as you can imagine, every year we have judges that become retired, that become sick. So that was a significant problem that courts were facing, was the lack of judges. And the last key measure that was taken is regards the regulations. And so some legal rules were modified or eliminated to speed up the decision time, meaning the time that judges take to decide a given case. So these 4 big measures was designed to address the issue of the cases that were pending, that were waiting for a decision in Portuguese administrative and tax courts. However, some other relevant measures were not considered in this reform. Notably, as you may know, Portuguese judges work alone. We do not have any sort of paralegal assistance. If I, as a judge, want to search the applicable regulation regarding VAT, corporate income tax, whatever, I need to do myself that search. I do not have any kind of assistant or assistance to help me to do that search. And so the judge do all of the preparatory work of the decisions that are issued. Next slide, please. Very briefly, let's just have a quick look regarding these measures, just to understand better what they are or how they were designed to address, to cope with this problem. So the teams that were constituted, that were set up to decide the cases that have been filed up to the end of 2012 were constituted by 22 judges that were recruited from courts where the caseload was lower, and they had a 24-month period to decide that cases. This 24-month period can be renewable once for an equal period of time. Since judges and courts gave the cases that were waiting for decision that have been filed up to 2012 for these special teams, presiding judges, as you may know in Portugal, each administrative and tax court has a presiding judge. Presiding judges with the judges of the court reorganize the caseload in order to achieve a balance regarding the caseload that is assigned to each judge. On another hand, Superior Council of Administrative and Tax Courts implemented a monitoring process regarding the cases of 2013, 2014, in 2015, in order to prevent the accumulation of such cases. Next slide, please. Specialization has been discussed in Portugal for many years because, as you may know, Big Four audit firms, the biggest law office in Portugal and in the world, are specialized by, for example, the nature of taxes, direct taxes or indirect taxes, or according with some business lines, financial line of business, assurance. And so in Portugal, the decision was very different. The specialization was made according to the nature of the litigation. If we are facing tax assessment litigation, this case will be assigned to the judges that belong to that team, let's say. If we are speaking about tax enforcement litigation, that including tax fines disputes, that cases will be assigned to the judges that belong to that specialized team in the tax court. The same with the administrative courts. It was set up 5 different areas: general, social, public contracts, urbanism, and environment, also aiming to speed up the decision time and trying to have specialized judges in order to reduce the time that they take to decide the cases. To properly provide judges with the appropriate tools, the government requested to Judges National Academy to provide relevant training to trainee judges and also to veteran judges. And so we in the Portugal School of Judges organized several conferences, several seminars, workshops on the basis on real case studies in order to provide practical training to judges, which were the type of training that judges were demanding to address the goal of specialization. Next slide, please. So, as you can see, and as I told you before, we did not have a recruitment policy that was consistent with the needs of these courts. And government changed that policy, and we expect to have in 2023 more than 100 judges that we had in 2018. We believe that at the end of 2023, we had the sufficient number of judges to address the needs of administrative and tax courts in Portugal. That was a big effort from the National School of Judges to train and to provide the necessary training for new judges to speed up his formation process and to allow that they go to courts properly with the proper knowledge to do well their work. Next slide, please. However, this reform forgot second instance judges and second instance courts. So the number of judges increased a lot in first instance, and so we may say productivity increased a lot in first instance, but as well as the productivity increased, the number of appeals increased also. So second instance courts are facing a huge increase on the volume of incoming cases, and the number of judges in second instance courts was not properly increased to address that huge increase of demand. So the Superior Council 2 months ago began the process to recruit judges for second instance courts, and we hope that briefly more judges will be named for that courts, second instance courts. Next slide, please. And to finalize my presentation, in a nutshell, as a conclusion, we may say that this reform was successful because the vast majority of the cases that have been filed up to the end of 2012 and were awaiting decision are now resolved, at least at first instance level. The other cases that were pending in first instance courts were decided faster. It is the so-called specialization effect, and this all combined brought a better image and more trust in the administrative and tax justice system, as well as a positive effect in the economy. However, and besides these good results, Portuguese government is now preparing a small reform, another one, as I point out in the slide, because Portuguese government and Portuguese people in general like reforms and like changing things. But now what is being discussed are small adjustments in the functioning of the courts. What is being discussed now are 2 main areas: the introduction of paralegal assistance for judges and trying to discover how artificial intelligence can help judges and the courts to improve justice in administrative and tax courts. Thank you so much for your attention.
Даруйте, не включився звук. Дякую пану Філіпу Едуарду за таку змістовну і цікаву доповідь.
Thank you very much, Felipe Duarte, for your very interesting presentation. And based on your presentation, what I'd like to say is that the problem of overworking with overloading with work rather is a problem not only in Portugal but also in Ukraine. Our judges are also overloaded with work in this area of specialization. Okay, we move on, and now I'd like to give the floor to Anton Monayenko, who will tell us about the EU practice in order to counter tax fraud. He is the chief researcher in the Center for Researching Interaction of Government and Civil Society from the Kyiv National Academy of Legal Sciences. He is also a member of the Scientific Consultative Council, PhD. Please, Anton, please take the floor. Good afternoon, dear colleagues, dear participants of the conference. First of all, let me thank the organizing committee of the conference for participating in this conference. Thank you for giving me the floor. The EU, over the period of its existence, had challenges such as double taxation, aggressive taxation, decrease of tax base, plus so-called privileged taxation regime. And one of the reasons of these challenges is the differences in tax systems among the member states, and also the use of different legal structures. Also, there is the range of mandate of the individual states means they have to abide by EU legislation and introduce changes in order to harmonize the tax legislation at the EU level. For Ukraine and its court practice, the use of EU court is an important practice. Of course, all the judges can say, well, we have the grand chamber, which clears or sets out all the principal positions, and that can be used in order to interpret national legislation in line with EU standards, but not as the source of law. Until the mechanism of using the EU court practice, unlike the European Court for Human Rights practice, because Ukraine does have a practice in this area. But the association agreement between Ukraine and EU means we have to take into account the position of the European Court, and in the foreseeable future, especially since Ukraine received the candidate status, and future membership of Ukraine will play an important role to form uniform court practice in order to settle tax disputes. In the area of direct taxation, three main directives have been passed. First, on general taxation system, which is used to parent companies of 2011. Second, about the general taxation regarding the exchange of shares. And the third directive about the general system of taxation of percentage, royalty, commission that are done by various EU companies. In all these three directives, there are provisions that allow not giving any preferences if the goal of a particular transaction is to avoid taxation. Now, persons are prohibited from using certain advantages and benefits envisaged by the EU law. And decision of 9th of March 1999 testifies to that fact. There's also a principle that says that the use of EU law cannot be used for transactions that are done not in the process of commercial activity, but in the process of obtaining illegal benefits. And the EU decision of 21st of February 1996 clearly points to that. There is also a so-called special principle, and if the transaction aims to get tax advantages, most likely this is abuse of law, and therefore no benefits or no advantages can be given. Now, in order to ascertain whether that transaction is fraudulent, then the goal of the transaction should be checked, and if there is doubt, then no benefits or advantages to that transaction can be given. The EU court in late 90s used a following approach. They looked at the significant goal because it's not easy to establish whether the transaction is pursuing the goal of getting advantages, tax advantages. Therefore, if the main goal is to get ungrounded or unreasonable tax benefit, then that qualifies as something something that triggers the ban on such transaction. Taxpayers often tries to avoid paying taxes, and for instance, a corporation can have a subsidiary registered, and that subsidiary is registered for the tax regime that pays a lower rate, and then the parent company acts on behalf of that subsidiary and thus gets an unreasonable and illegal advantage.
Законодавство про КІК, контрольовані іноземні компанії.
Now, speaking of the legislation on controlled foreign companies. At some point in time, there may be a collision between the mentioned legislation and the country's aspiration to keep the freedom of establishment. The mere creation of a branch company in another country in order to optimize the tax assessment is not an offense itself. The decision of CJEU of the 19th September 2006 testifies to this. In that case, the Court of Justice established that the establishment of a branch in another country may be perceived as a violation, as an offense, if the purpose of such a setup is tax evasion, in particular the attempt to evade VAT payment. Now, in case Cambridge-Schweppes case of 2006, the court established that the absence of a direct tax assessment may constitute fraud. Another thing which may be considered as a violation is acting in a manner to obtain advantages granted by EU directives. Here we are talking about so-called mailbox companies or transition companies which do not exist in reality, but are only created with the sole purpose of using their legal address for respective transactions. Another CJEU case of February 2008, the court said that transactions and agreements with mailbox companies may be acknowledged as null and void. And companies that established mailbox companies may be recognized as companies creating artificial schemes, and then it is the task of the prosecution to prove tax evasion or tax abuse. The CJ EU jurisprudence also says that in order to prove tax evasion or tax abuse, respective authorities need to check each and every transaction.
Липня 1997 року було встановлено, що операція, яка має належну комерційну причину, повинна мати не тільки мету утримання фіскальної переваги певної якоїсь.
Now, the Court of Justice states distinctly, starting from 1990s, that for a transaction to be recognized as fully legitimate and not possessing any signs of fraud, it should be of a clearly commercial nature. Absence of commercial purpose can be proved by the following facts. Basically, absence or impossibility of exercising similar transaction by third independent parties. Second, absence of clear commercial interest. Third, failure to exercise actual economic activity in the territory of the state where such company has been established. There is a series of other features, but I listed first the most important ones. Thank you very much for your attention. Mr. Monayenko, we are grateful for such an interesting and detailed speech. And I fully agree with the statement you announced at the very beginning of your today's intervention, since Ukraine is aiming joining the EU family sometime in the near future. We need to look into European jurisprudence now, earlier rather than later, and we need to at least aspire to harmonize our internal jurisprudence with the existing European case law. So again, thank you very much. Let me remind that at the end of session, there will be time for questions and answers. Now I'm very pleased to give floor to my colleague from the Cassation Administrative Court, Judge Irina Jeltobruch, who will develop on the administrative court going beyond claims, in particular on imperative issues and procedural limitations. Judge Jeltobruch, the floor goes to you right now.
В нас знову виникають певні технічні проблеми.
It seems that we are again facing some technical constraints. Irina, we cannot hear you. It seems that Irina needs to switch on her microphone. Indeed, my sincerest apologies. I failed to switch on my micro. You may have heard, I've already presented, introduced you, and I announced the topic of your presentation. So please, you are welcome to start. Please tell me whether you can see my presentation. We could see it a moment ago. What about now? Now it's good. In the first place, dear participants, welcome and thank you for being here, even though it is online. 2 months ago, we could not even dare to imagine, to hope that we will be able to gather all together. Hopefully, we will see each other offline very soon. It's not by accident that I chose this topic as a topic of my today's speech. Once one starts applying law in practice, many problematic issues come to surface, and in this is why when I became a judge, I realized how often administrative court is in the position to go beyond the claims, and how often administrative judges need to address to the principle of dispositivity of law. So this can be explained by the fact that administrative law leaves very little space for interpretation by both administrative authorities and judges who are entitled to deal with such cases. For instance, if you look at Article 5 of the law on administrative procedure, you will see that it combines both reasons for a basis for going before court with administrative claim and possible remedies. So when it comes to taxpayers and possibility to protect their rights before administrative court, it is extremely important to bear in mind that the respective legislation needs to be presented as clearly as possible. There are several remedies for the administrative court to restore violated rights of taxpayers. These remedies are balanced so that I'm sorry for interrupting you, Irina. We cannot see your slides, unfortunately. We can only see the very first page of your presentation.
Ви можете просто вийти з повного екрану і показувати нам так.
Це було б гарно, якби я знала, як це робиться.
Escape на клавіатурі. Вийти з повного екрану.
Yes.
The technicalities are now being addressed. Nothing has changed so far. I'm very sorry for interrupting you.
Я escape нажимаю.
Ви зараз бачите на весь екран свій слайд, так?
Даруйте учасники за таку технічну, бо буває в нас все ж таки техніка і проблема з...
Dear participants, apologies for these constraints since we are using modern technologies for conducting this conference. We are sometimes unfortunately limited by what the technical side may sometimes bring as a problem. So I will continue. There is a list of remedies the administrative courts may apply with use of discretion to certain extent. Discretion can be translated in the possibility of administrative court judges to go beyond the administrative claims. So when the judges may go beyond claims in cases if the claims are formulated insufficiently, or if a judge understands that the claims are intertwined with other violations which are not part of the lawsuit. It may be a combination of both. So there is number of reasons actually. If we look at jurisprudence of the cassation administrative court, one will see that sometimes first and second instance courts of administrative jurisdictions refuse to deal with disputes on tax document registration just because the plaintiff failed to mention that he or she would want to see cancelled the respective decision / act of the tax authority. So based only on this small deficiency, the first and second instance courts of administrative jurisdiction refuse in consideration of disputes on merits. So it is clearly a deficiency in administration of administrative justice.
Що основним джерелом невизначеності є законодавче формулювання, яке визначає вихід адміністративним судом за межі
It is clear that the core problem here is a lack of legal certainty as to whether administrative courts are supposed or not supposed beyond the claims when it comes to disputes between the state and individuals.
Інакше кажучи, виконання завдання адміністративного судочинства є найбільш пріоритетною функцією адміністративної юстиції та не може залежати від судового.
In other words,
випливає імперативний для адміністративних судів виходу
administrative jurisdiction in our opinion should possess sufficient legal possibilities to effectively protect legitimate rights and interests of individuals, even in situations where the claims submitted, the lawsuits submitted by such individuals might lack certain formal formulations or references. The same applies to other disputes other than tax disputes. For example, when it comes to administrative complaints against actions or omission of medical practitioners, the claims are often rejected just because, in the opinion of administrative judges, the claim is formulated without mentioning the need to cancel the respective medical documents issued by medical practitioners.
Also the duty to ensure disposition is stated in many legal acts of foreign nations. And what catches our eye is in line with Article 5 of the rules of civil processes in the UK, the court can use any legal remedy that the applicant can hope for, even if it is not stated in the applicant's statement. Also, in Poland, for instance, the law on administrative litigation, the court needs to consider the case within its limits and take into account the legal validation. There's only one exception, and that is for cases of challenging tax consultations, which can only rely on violation of procedures or wrongful legal evaluation of circumstances of the taxpayers. And in such a case, the legal validation is mandatory in the law or Polish law. As far as Germany is concerned, Article 88 of Article of Administrative Litigation cannot go beyond the rights, protection of which is required by application, but it's not linked to versions of respective legal requirements. And it can only be based on facts and research of evidence that was presented. In other words, if the parties could not submit objections to particular facts and the court did not consider that in open process, in such cases, the court cannot rely on that. Also, from the legal conclusions of the Supreme Court means that the goals of administrative litigation should go beyond the court demands and be based on the fairness and justice of the litigation. And going beyond the applicant's claims, there should be appropriate remedies selected to ensure more effective protection of the violated rights. But this cannot lead under no circumstances of deterioration of the applicant's circumstances. In other words, there cannot be replacement of the free will of the applicant. Also, circumstances that the applicant could not object to cannot be used in the process. So going beyond the demands of the applicant in the public government relations is the duty of administrative court. to achieve this goal and using the principle of using all official rights, there can be no compatibility with formalism, and the court should ensure the most effective protection as possible without limiting the rights and legal interests of the applicant. Even if there are grounds to believe that from the circumstances, it can be construed that some rights were violated. Also, this cannot lead to stripping the subject of authoritative mandate to limit the rights of that individual or the authority, although there could be exceptions, such as for the society, it is important to receive the method or that the court used to arrive at their decision. Thank you for your attention. Thank you, Irina, for a very interesting presentation. We apologize for technical issues. It does happen, but this actually makes us think, because going beyond the limits of the applicant's demands in public legal relations, such as tax litigation, is actually the duty of administrative court. And you've stated correctly that we probably need to be mindful of the fact that the court may replace with its position the free will of the applicant seeking protection. So it's a hotly debated topic. So thank you for your presentation. We continue our conference, and now it is my pleasure to give the floor to Oleg Yagnitsky, a master's degree, a dean from Ivan Franka University in Lviv, searching for objective truth about circumstances and facts is not possible without proving. So the admissibility of evidence by controlling authorities after the challenge decision has been presented. So Oleg, please, the floor is yours. Thank you, Igor. I am displaying my slides now. Can you see my presentation? Yes, 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 we can. We're not sure whether we can operate it though. Can someone administer the screen? Could you give the rights for me to manage the slides? Unfortunately, I can't do that. If you simply ask me to change the slides, I will do that for you. Okay, dear ladies and gentlemen, it is my pleasure to participate today in this conference. Indeed, as head of the Legal Academy stated, Mr. Petrushin, the Supreme Court of Ukraine today is really the powerful center for formulating court doctrine, and it is a pleasure to read decisions that enrich us in new concepts, and this way we use the remedies in the most effective way. The topic that I'm trying to cover was born in the latest offline event that we had. It was a Supreme Court and the Tax Administration joint roundtable discussion. But the tax legislation, of course, changes, it evolves, and based on our own experience, we renew our own approaches, and you can't really rebuke the court authorities for certain stability, because it is only natural that things evolve and change. Proving is one of the important elements for any form of justice, because the issue of fact is just as important in the context of fair justice from the standpoint of the users of justice. If the court fails to ascertain objective truth and therefore wrongfully qualify the relations, no matter how correct the application of norms are, it will never be understood by the parties, and parties would leave the courtroom with a feeling of unfairness. Therefore, all forms of litigation and justice are based on facts. Did those or this or that particular fact occur? Are they reinforced by evidence? However, the burden of proof is also a very important element of any system, including the government, for example, whose actions or omissions can become a subject of discussion and consideration in court. For quite a long time in Ukraine, the concept of validation of court decision was part of the court positions, but now the situation is changing. Next slide, please. Today, we have the law on administrative procedure, which should become a helper to all citizens in order to define the relations between the entities with respect to individuals. And also there's an issue of proof and ensuring validation of decision. In fact, the standards of proof is described in Article 6, which talks about legitimacy, or Article 8 talks about validation, and Article 16 talks about officialness. And it requires from the administrative body to ascertain all circumstances of the case, both the ones that are conducive and the ones that are negative for the party. And there's also an imperative requirement of validation of any administrative act, including the ones that can adversely affect the rights and interests of an individual. And Benjamin Franklin talked about death and taxes. And of course, acts in tax relations are potentially the negative act as far as the rights and interests of an individual. One of the important aspects of the law where we use the synergy of competitiveness as well as official clarification of all circumstances of the case. Official clarification of all circumstances of the case has two sources. First, it is to do with the fact that unlike civil or commercial litigation, administrative litigation not only settles the dispute, but it has also a goal of a control over the organs of government, because administrative courts has to also verify activities based on certain criteria, regardless of the subject of the complaint. So for administrative court, disposition and the circumstances and the limits of the applicant's demands can always be expanded, and due to the principle of proof, the courts are trying to balance the inequality between an individual and the state, because the Article 3 of the Constitution states that the government, the state, is always responsible before individuals, before citizens, for their activities. At the same time, the official ascertaining of the circumstances of the case is often perceived as an inquisitive process. But what it is about is the private aspect of human rights friendly, which seeks to ensure, to the degree possible, a full control over the activities of the government authorities, and administrative justice does not transgress the field of the government or correcting the shortcomings. If the organ of government during the decision-making process did not validate it properly, did not communicate to the applicant the circumstances of making such decision, if such circumstances arise in court, paragraph 2 of Article 77 has an important procedural hurdle for cases of omissions. The government entity cannot refer to those circumstances, with the exception of cases that we're going to cover next. In fact, in such cases, based on the concept of using the burden of proof in administrative courts, Volodymyr Bevzenko, a judge, a PhD, who is, by the way, fighting right now at the front, he stated that the volume of evidence and the subject of proofing is usually formulated at the first instance level, and it basically remains unchanged. However, if we look at the provisions of the law on administrative procedure, which is the section 2 of the same article, it says that depending on the arguments and circumstances that administrative body validated its decision for a particular action or omission, administrative court is limited as far as confirming the validation of such decision, whether it was sufficiently grounded and validated. So in such a case, we are talking about proper validation. And when we consider potential challenging of decision of a government body, they need to see if they can use respective decisions.
Докази на цій стадії за загальним правилом вже подаватися не зможуть. І таким чином адміністративний орган не зможе перед судом заявити про те, що він мав всі підстави для відповідного прийняття оскаржуваного рішення. Фактично, ще раз анімація, фактично такі нові докази будуть вважатися недопустимими, виходячи із сукупності приписів статті 74 та 77 Кодексу адміністративного судочинства. Наступний слайд. Однак, чи є це обмеження на подання нових доказів абсолютним імперативом? Ні, тому що, як я згадував, 77 стаття...
канал, будь ласка.
Прошу?
Перекладач, змініть канал перекладу.
Оскільки частина 2 77 статті говорить...
However, it is a question whether the such a requirement of non-submission of evidence at later stage is imperative. After having analyzed in detail the respective jurisprudence, I would suggest to focus on two main aspects. First, evidence which validate the legality. Even if they were received in the first stage, cannot be decisive, even though their importance and their weight is undisputable. And second aspect we should focus on is consisting the following. New evidence, in my opinion, can be submitted before court with explanation, with the reservation. So such new evidence can be submitted by the tax authority if the claimant has submitted new evidence, and thus by submitting new evidence, the tax authority responds to new evidence submitted by the claimant, by the taxpayer. Now, let me make reference to a ruling issued by Judge Olander, who said that opinions presented in respective acts issued by tax authorities following inspections can be admitted by courts as evidence. Even if such acts do not contain what is understood by the administrative court as a reasoning part or motivational part. In the meantime, the taxpayer may submit additional document and provide additional explanations, which is provided by Article 86 of the Tax Code of Ukraine in response to the engagement of above mentioned acts issued by the controlling authorities following the inspection. Does it mean that tax authorities should be deprived of the fact to submit additional evidence at a later stage? I beg to disagree. I think it would be wrong. Based on my own experience and based on discussions which took place in Kharkiv Law University. By the way, the above mentioned events, conferences were attended by foreign experts as well as by Ukrainian lawyers, and both are unanimous and agree that the tax authority cannot be deprived of the right to submit additional evidence. However, it cannot be but stated that the conduct of a taxpayer has a direct relation to the scope of proving and detailization of motives of a controlling authority when issuing an act, a document following the inspection of such a taxpayer. It is of extreme importance to ensure proper reasoning of inspection statements by tax authorities. In the meantime, the taxpayers should be obliged to provide all necessary information to the tax authorities when inspection or control is exercised. This will reduce number of administrative disputes on the matter and will reduce the burden of administrative courts. Thank you for your attention, and I'm ready to answer all and any question. Thank you. Thank you, Oleg. It was indeed a very unexpected and fresh opinion on the topic. We will see whether anything will change in this area and whether the legislator together with the judiciary will manage to introduce necessary amendments and changes in the process of proving and in the respective regulations on admissibility of evidence in tax disputes. Thank you very much, and I'm sure there will be questions from participants at the end of the session when all the speakers deliver their speeches. Now, we are moving forward and we continue with the next speaker, Pavlo Lutikov. Apologies. It seems that the next speaker will be Mykola Sambor, head of the monitoring sector of the Prилуки District Police Department. of the National Police in Chernihiv Oblast, deputy of Preluki District Council, and member of the National Academy of Sciences of Ukraine. Mr. Sambor, the floor goes to you. Dear participants, thank you for having me here. Thank you for giving me this opportunity to develop on the topic, which I chosen as the topic of my intervention. As we all know, taxation is an issue which is on the crossroads of public and private interest. Ukraine's legislation says that taxes should be paid by individuals and legal entities on a timely and a regular basis. It is not just a requirement, a groundless requirement. We all understand that this is something which ensures proper operation of the state and facilitates the state to comply with its obligations. Thus, the necessity to properly regulate payment of taxes, levies, and duties becomes more and more acute and topical every day. Let me now develop in more details on the court fee. The court fee is a mandatory payment which is required from all individuals and legal entities with legitimate exceptions for addressing to courts. The court fee is used to finance activities of courts at both pre-trial and trial stages. This is what states the law of Ukraine on court fee. The court fee is paid alongside submitting a lawsuit before court. In the meantime, the same law says that if in a dispute between a public entity and a private individual or private entity, the court adjudicates in favor of the private entity, all court expenditures should be reimbursed to the private entity from the state budget. In practice, it is sometimes problematic. It is sometimes problematic to ensure practical implementation of this requirement because of the lack of budget funds in respective local authorities, as the reimbursement takes place at the expenditure of local authorities. And in the meantime, it leads to a situation where local authorities actually lose money because of improper actions or omission committed by an administrative authority. Now, coming back to the court fee, as I said, there are some legitimate exceptions as to the payment of the court fee. Some categories of individuals and entities are exempt from paying the court fee. It comes in particular to vulnerable court users as well as to claimants going before court with labor disputes, certain categories of family disputes, such as payment of child allowances, and people, court users going before court with disputes as to the amount of and calculation and payment of pensions. These categories of disputes constitute important part of caseload of administrative court. In the meantime, and some certain disputes are of systemic nature, which leads to increased number of cases which are not backed up with any court fee, which leads to underfinancing of the judicial system. Many systemic problems, systemic disputes are related to disputes between individuals and the pension fund of Ukraine. Many disputes relate to calculation of pension and the procedure for payment of various types of pensions. There is a trend to decrease the amount of pension allowances every year, which inevitably leads to disputes in the area, since citizens claim that decreasing the amount of allowances contradicts their rights. In the meantime, we cannot but remember that Article 13 of the law of Ukraine on judiciary and the status of judges tells us, states us that jurisprudence can be used as a source of law when adjudicating in certain categories of cases covering the issues which constitute systemic violation. This, in theory, could lead to the decrease in number of typical complaints, typical claims, and typical disputes. So, having such jurisprudence enshrined at some formal level in the form of instructions or regulations for administrative authorities with clear indications of previously committed violations may, in theory, lead to more human-friendly behavior of such administrative institutions and potentially lead to the decrease in number of respective disputes. If done so, it will mark a new stage and a new level in the development of social relations in our society, where the administrative justice is indeed the one preserving and protecting the rights of individuals and private institutions.
Забезпечить захист державних інтересів шляхом
I'm sure that we can ensure
судового чи
we can ensure the protection of the rights and freedoms of citizens and ensure the effective use of resources in the country. This wraps up my presentation, and should you have any questions or comments, I'll be happy to take those. Thank you. Thank you, Mykola, for your interesting presentation. Dear colleagues, it happened so that one of our presenters was unable to attend to make his presentation, but this leaves us more time to have a discussion, ask questions, get answers. So should you have any questions, feel free to come up with those questions now. With your permission as a moderator, if you don't mind, I would like to set the tone for the discussion. And first, I'd like to ask Henrik Schutzmann and ask him what is understood based on his presentation by approaches that allow the duty for the taxpayer to not pay taxes through failure of the legislative power to establish the equality amongst the taxpayers. Perhaps you have some examples from the practice of the federal court in Germany.
Yes, the consequence of tax law being void and thus prohibiting the state to earn the tax must be extraordinary. Otherwise, the judiciary would deny the legislation to impose tax upon the people, which is contrary to the constitution, of course, and would harm the state. But it has to be reduced to extraordinary contradiction of law. If such cases where the tax law, for example, says in the interest, taxation of interest, everybody who earns interest has to tax it by 25%. And if on the other hand, the state says the banks who produce normally most of the interest are not obliged, and the administration does not have the right to really ask the banks what the profits the people have earned, then there is no possibility for the state and for the authority to really check whether or not people tax their interest. And in these cases, it's only the very few number and every person normally taxes only what he has to. A very few number of people will be taxed, and if this is due to the fact that the law is contradictory, that's on the one hand say everybody has to pay, and on the other hand say we don't allow you really to check, and it's only the very few that do it by themselves that are taxed. This is in such a way contradictory that we don't allow you to tax it. But it's really an extraordinary consequence. The probably more important for the legislation is what the Federal Tax Court has said last year. They say even now they admitted they have problems with the gastronomy and this possibility of taxation. They say even if it's not that extraordinary contradiction, it is contradictions, but it's not that extraordinary. Still, legislators have the obligation to see what is happening, to see what you control, and to not leave it by itself. And so they are within an obligation to see, to control, and to do what they can do. That is probably the message the court wanted to give. You always have to look after it, and things change. You have circumstances that change. 20 years ago, digitalization was not a big thing, but nowadays it's much more, as you see by our conference today via Zoom, it's much more common sense that people have everything on their computers, on their smartphones, etc. So if there are new possibilities for tax authority to check and to control, and for the taxpayer to contribute to the admission of tax, you have to, at some point, you have to use it. And if you don't use it as an administration, the court maybe someday said, okay, you had the possibility, you knew that you had massive problems, and you didn't act. So maybe this is the point where they say, that's void.
Дякую, пане Генрік, за таку змістовну відповідь. Дякую.
Thank you, Henrik, for your answer. Are there any other questions from the audience to any of the presenters? If there are, please, now is the good time to ask your questions. If you don't have, actually I have, if you don't mind. I have a question to Irina Zheltobruk and Oleg Rivnitsky. First question to Irina Zheltobruk. Where is that borderline between the duty and impossibility to replace the will of the applicant in court? What criteria the court should rely upon? With your permission, the boundaries are actually something that begs a more detailed scientific discussion, because the applicant can challenge the violated rights within certain limits. And in order to find out if the applicant is willing to defend this right and within what boundaries, this, in my opinion, should be discussed in courtroom. This is not regulated to a large degree of detail. Therefore, we can discuss it only as researchers, not as judges. I believe we need to communicate closely with parties in court, try to find out as many details of the applicant's demands as possible, trying to understand exactly what is it the applicant wants so that you don't substitute those with what you think the applicant wants. All right, thank you for your answer. It is indeed a very broad subject, and indeed one could discuss it quite extensively. And now I have a question to Oleg Ilnitsky. Regarding the standards of proof, you focused attention on the unique features of tax litigation, tax disputes. In the algorithm and in the approaches that you mentioned, do you see the area of applying Article 46 of the tax code, where they talk about the duty of the taxpayer to provide all the documents or evidence, essentially, documentary evidence? And the lack of such evidence may render all the other arguments of the applicant nil. What do you think, Oleg? Well, actually, my last finding boils down to the following. When we talk about the volume of proving, actually, your latest remarks about changes in Article 77, they have been softened with the adoption of the law on administrative procedure, and controlling bodies now can ascertain the volume of their decision. So at the stage of court hearing, we will all know what factors were taken into account, what circumstances were looked into, and the need to talk through the circumstances. So administrative procedure uses the same concept. The taxpayer who did not get a chance to speak out in the courtroom, the volume of evidence in administrative court based on Article 2, the controlling body cannot legitimately refer to the new evidence that to come. But the taxpayer should also be mindful of the fact that in the administrative procedure, he also shoulders certain responsibilities. So if the taxpayer, in contradiction to his opportunities, did not present the evidence, did not affect the volume of proof, any new arguments during court hearing, and again, we cannot say that it is imperatively impossible, because circumstances may vary, of course. Some may explain why applicant didn't come up with his objections, but it is the duty of court to look into this and come up with findings and conclusions, whether the taxpayer had an opportunity to present his evidence or not. Was it done in good faith? Or were the procedural rights violated? And was there any abuse in procedural rights? And administrative procedure actually focuses on this situation, and government bodies have similar headaches, similar headache as the judges, because in the future, the discretion will be limited because the law will clearly state every step. Therefore, I believe it's a two-way street, really, both from the standpoint of good faith of the government authority, as well as the good faith on the part of the taxpayer. Thank you, Oleg, for your response. I think we have a question from Irina. Not so much question, but since we are having a discussion, I just wanted to perhaps present my own view on what Oleg was talking about. The thing is, you can't take away the foundations from the volume of proof and proving, because the tax authority has a fairly limited subject compared to the court hearing. The exceptions for Article 464 are different. Therefore, a person can truly believe that this issue is not contradictory. But in the court hearing, in the court ruling, see the reasons why the decision taken was not in his favor. Therefore, I'd like to urge a more cautious approach when deciding on exemptions and the scope of proving. Thank you for that nice addition. Colleagues, are there any more questions to our presenters? Because if there aren't any, we could then wrap up our session. I'd like to thank you all for your interesting presentations, for this very fruitful discussion, and I hope we will continue to holding similar workshops. And now I'd like to invite you to join the next session, which will start at 4 p.m. And now we will have a 15-minute break. My colleague, Supreme Court Judge in the Cassation Court, Микола Гімон. I thank you all for this very interesting session. I wish you a good day and all the best.